Do you know how a trust works? Do you have a will, and is it current? Estate planning can be confusing and overwhelming. In this next segment, Donna Jackson breaks down important estate planning concepts and how they can apply to you.
The first time I came to Donna's office was probably 20-some years ago, and my dad and mom had a fairly decent estate. My dad started this steel company when I was in high school. In his process of trying to get out of the business because he was sick, we wanted to save it, and we knew that we could keep it in the family, which is what Daddy wanted and was what we wanted.
Part of my job is to bring peace to the client and the family, and I like the word empowerment, because a lot of things that we do, especially in Medicaid planning or VA planning, kind of takes control out of the client's hands. And I think it's important to do estate planning where the client maintains control as long as possible, because we lose control over our bodies and our minds more and more every day. And so a lot of my clients, because they grew up during the Depression, they like it that they can give peace of mind to the clients and stay in control. Daddy
wanted to retire. He was not able to because there was a partnership between he and another person. And so we ran into some legal issues there, and Donna helped set up Mom's and Dad's estate in a trust, which saved us a lot of money, and then she's guided us into our personal estate. And several of my family members have had trusts.
A trust is really, it's kind of like a contract, but not. Because once a trust is set up, it's considered a separate legal person in the eyes under common law and under the statute. And there's three parties to a trust. There's the person that establishes it, which I call settlor, but it could be grantor, trust maker. All it means is you own the trust. And then there's a person that manages the trust. And they're not called president like you would if you set up a corporation, but they're called trustees. And it's important, my clients start out as the original trustees, and then we have people that will take over when they become incapacitated or pass away. And like if you had to name a new president of a corporation, you'd have a meeting and the shareholders would vote on appointing a new president. But in the document itself, it names who the successor trustees are. And if they're not available, I always draft it in that the beneficiaries, which is the third party of the trust, that's the one that gets to enjoy the money, can name another trustee. Because the last thing I want to have to do is have to go to court to name a trustee.
We decided, my wife and I, when we lost our parents, we already knew that we started accumulating assets, and we've accumulated more and more, and we didn't take their assets and spend them. We created more assets with it. So we've done the same thing to try to protect the estate where we can pass it on to our children and grandchildren.
I didn't realize how important it was to set up an estate if you want to pass it on to your children. And we wanted to keep Daddy's steel company because our youngest son is an engineer and he works there, so it was important for us to keep everything that we had.
We started working on it before I actually met Donna, but after her folks, that's when we decided to go ahead and set up the trust for her, and it's just to protect everything. And it's just silly to pay that probate cost, and if you set it up right, you don't have to pay a lot of estate tax.
Most people don't want to have to go to court or probate when they pass away. And so somebody can die with a whole bunch of assets or very few assets and not have made any planning, no will or anything, and that's called intestate, without a will. And the state has a statute that explains who gets what when somebody dies without a will. First of all, you have to go to court and name a personal representative, and whoever files first is usually the one named, and it may not be the one you would want to be in charge of your estate, and you're probably rolling over in your grave.
The thing that makes a trust most attractive to me, and how Donna explained it, you put all of your assets into it, so you really know what you have, and if everything is titled right, you don't have to go through probate. It makes it so much simpler upon the death of a loved one.
The minimum you need is a will, so you have to use the intestate statutes to decide where your property goes. At least in the will, you name who's going to be your personal representative, who's going to be in charge, and where the asset goes. The trouble with the will is people come in and say, I have a will, that means I don't have to go to court. All a will is instructions to the court. It's your instant ticket to probate court. It doesn't keep you out of probate court, it invites you into probate court. So to avoid probate, you need to do a trust, and still you need a good estate planner to go over your options there.
The end of life, especially if there's illnesses, is quite difficult to deal with. And you have to know sort of what they want, and if they put that information in a trust, it makes it easy to handle their finances, because they might linger. My mother was a stroke victim for 6 years, and my dad had passed away, so you had to handle all her finances and everything. And if you don't have the means to do this, it's quite difficult. And like I said, it's the emotional. You're losing your mom, and then you still have to pay the bills and do everything and make sure that you do everything right.
A trust keeps it out of probate court because once the client, the settlor owner of the trust, signs it, the trust becomes a separate legal person in the eyes of the law, like a corporation, and it doesn't pass away or become incapacitated when you do, because we got successor people named to take over. And the most important part for the trust to work is that your assets have to be retitled to the trust name, not stay in your name. And so that's the reason I think reviews are very important, because a lot of my clients, as they get older, they're back renewing a CD in their own name and not in the trust name. They're buying a house or a farm in their own name and not in the trust name. So I need to make sure that everything's properly titled after they leave my office.
It's a never-ending planning. It doesn't stop. You can't just do it one day and say, hey, we got it fixed, because things change, laws change, so you got to keep working on it.
I want to be able to give my children what we have accumulated. What we've worked hard for. That's why we're still working, is because we want to have this stuff for our children. I don't want someone else to have it. Yeah, and that's just the way my parents were too. They worked hard for it, and it was theirs until their passing, and then they passed it on to us, and I know that that's what they wanted for us to keep it for these grandchildren, their grandchildren.
I could remember the taxes my dad had to pay and the probate cost of selling the estate it wasn't a lot to today's money, but it was a lot of money back then, you know, and it's just thrown out the window. All the deaths we've experienced that we set up trust, it's just made it so simple.
Most people don't think far enough ahead. The what-if game is, what if you and all your kids and grandkids were on the same cruise ship and you didn't come back? Who do you want to leave it to? Do you want to leave it to your quote-unquote relatives, or do you want to leave it to charity or friends? And most people don't think ahead. If you don't think ahead, it's going back to what they call heirs at law. And if you don't have any heirs at law, it's going to go to the state of Oklahoma for common schools. So it's better to plan ahead and have control over what you're doing with your estate and your life.
Here to discuss estate planning are Stacy Dillard Self, who is in private practice in Oklahoma City, Emily Crane, who is a trust officer from Oklahoma City, and Don Hallman, an estate planning lawyer from Norman. Don, a lot of people fear going through probate. Why?
Well, there's three main reasons and problems with probate. The first one is that it takes a long time. The average probate in Oklahoma is 9 months to a year to get through the process, and that's without any fighting or any issues that pop up. The second reason is it's super expensive. The average probate in Oklahoma is 10% of the assets that go through probate. And the third reason is that it's all public record. So no matter who you are and what you die with is all going to be down at the courthouse for your neighbor to go down and find out and look up.
Stacy, what do you tell people when they're trying to decide whether they need a will or a trust?
I usually tell people that a trust is going to be beneficial because you're going to save that cost of a probate. Because if you have a will, you're still going to possibly have to go through probate more than likely, because if you have any titled assets, they need to go into a trust to avoid having to pay the money to do a trust or a will, then turning around and your family is having to pay the money to pay a lawyer to go through probate to transfer that titled property.
Emily, are trusts difficult to do? It sounds like there may be a lot involved in the titles and identifying all of the property and the assets.
There's more work to set up a trust. If you have a trust, you have to first draft the document, but then you also have to go back and make sure that your assets get into it. So if you have real property, you have to deed that real property into the trust. That would include minerals. If you've got minerals, those have to be deeded into your trust too. If you've got bank accounts, and most people have one of those, that has to be titled into the name of your trust. So you've got legwork after you sign that document. You're going to do some legwork, making sure your assets are in it.
We heard the term intestate statutes. What is intestacy?
So I always tell my clients that means the great state of Oklahoma is going to write a will for you. So it doesn't necessarily mean it's all going to go to your spouse. Typically, it's a combination of going to spouse and children. If somebody doesn't have children and they just have a spouse, then I recently had a case where it went a third to the spouse and 2/3 to the brothers. So it just means that we're going to use the laws of the state of Oklahoma to determine where your stuff goes.
If you don't have an instrument.
That is correct. And so at least that's what a will does, is it's a set of instructions of here's where I want my stuff to go. The biggest downside of just that set of instructions is that it will go through probate in order to get to those heirs.
Are there any other ways to avoid sending your assets through probate?
You can do a beneficiary designations on certain things like bank accounts. You can do payable on death. You can do transfer on death deeds. If you have a small estate and you don't want to do a trust. Trust is always better because it's going to encompass more, but there are some ways to do it, but then again, it involves planning.
So Dick, I tell my clients this. I say everything that you own has to go one of three ways when you die. It either has to go by operation of law, what we were just talking about, beneficiary designation, co-ownership, has to go through probate with or without a will, or it has to go through a trust, right? So that's where maybe the trust officer comes in if it's a corporate trustee, but the trust bifurcates operation of law, bifurcates probate. So those three ways that property can pass are really mutually exclusive.
Emily, there's been discussion about the cost. We talked about it earlier. What's the cheapest way to handle all of this?
Okay, that's an interesting question. The cheapest way is to do it yourself, and then your heirs will be paying for it later. I mean, as far as costs go,
Hard to say?
if you go to court, I think there's probably more opportunity that you're going to pay more because you've got notice going to a lot of different people about what's happening. So if you go through probate, you have to notice a lot of people, all of the possible heirs at law. You're going to notice all of your creditors, and they each have an opportunity to engage in that process. So they all know what's going on, and sometimes people react differently to that information.
There's more to estate planning than wills and trusts. What's a power of attorney?
So a power of attorney is the document that basically says anything that I can do, Dick, if I point you my power of attorney, it says anything I can do, you can do for me. So that may mean a general power of attorney that would govern things like you being able to cancel my credit card, change my cell phone plan, move my utilities. And then there's a medical power of attorney that governs all day-to-day medical decisions. And really a trust that governs the money, power of attorney that governs the day-to-day decisions. Those two things working together ideally are what prevent a guardianship from being appointed to the courts.
What happens if you have to go through a guardianship?
Well, if you have to go through a guardianship, a guardian is someone who's appointed to, when someone becomes incapacitated, they can no longer give that power of attorney to someone. And so someone needs to take care of those day-to-day needs and pay those bills and access those checking accounts to do the day-to-day things. And this person is incapacitated and no longer has the legal ability to do that for themselves. So then that's when a guardianship has to be appointed to make those decisions for that person because they can no longer give the power of attorney to someone.
And it's important to remember on both of these issues, guardianship and a power of attorney, is that that power ends at death. I know I get a lot of calls. Well, so-and-so is the power of attorney, but you know, the person who created that document is dead. Your power as attorney, in fact, vanishes, or as guardian vanishes the moment that someone dies, and that's not well understood. So,
Stacy Dillard Self, Don Hallman, and Emily Crane, thanks for joining us on Ask a Lawyer.